This morning we heard the news that President Cyril Ramaphosa had signed off on Parliament's decision to impeach former public protector Busisiwe Mkhwebane. This after a protracted Section 194 parliamentary inquiry found her not fit to hold office. But the former public protector has already indicated she will be challenging the impeachment decision in the courts. So let's discuss this now with legal analyst Benedict Phiri. Benedict, thanks so much for joining us. So the former public protector said that she's going to challenge this. On what grounds would she be able to successfully launch an appeal?
It's very difficult to
Benedict,
me
I think you might be muted. I'm so sorry.
I'm hoping you can hear me now.
We can, loud and clear.
I don't know what happened there. But just to go back to the question, Sally, and thank you for having me tonight. It's very difficult for me to work out on what grounds the former public protector would be able to bring a successful review in this respect, because, you know, if you take it back to its inception, the work of the inquiry initially, that hasn't been reviewed, and that was a recommendation into the work of the committee. I think the work of the committee was quite thorough, at sometimes frustratingly so, and it looked like, you know, it was to appease Advocate Mkhwebane more than sort of get on with the work. And I feel like it was fair to her in the overall scheme of it. And the recommendation that the committee made is actually a rational recommendation when you look at what kind of evidence was actually presented there, and the fact that Advocate Mkhwebane didn't put up much countervailing evidence herself. And the work of Parliament cannot be reviewed. It was a simple vote that was taken in accordance with what the Constitution requires, and thereafter the President simply rubber-stamped the decision. So I fail to see at what point in that chain Advocate Mkhwebane could bring a successful review and application, and on what basis. So I think it will be very difficult for her to review any of these decisions.
Also, I think this is the very first time we've had an impeachment in our democratic history. So understanding how an impeachment can be challenged in court, I would imagine that we are in unprecedented territory legally?
We are in unprecedented territory in the sense that, as you mentioned, it is the first time that a public protector has been impeached. I think, though, when you consider you know, the work of the committee and the recommendation, as well as you know, the resolution by Parliament, and actually what went into that from the get-go, I think even developing the rules for impeachment themselves as directed by the Constitutional Court, I think it has been uncharted territory, but I think even legally it all stacks up. So I don't even think that there'd be grounds for a court to have another look at this, because it looks like, you know, most of the actors in the chain have actually done what has been required of them constitutionally. I do take that there may be a different interpretation, but certainly from where I'm sitting, I think, you know, all of the actors have actually done what they were required constitutionally here.
Yeah. If you had a client who nonetheless said, well, I want to appeal, where do you start? What do you look for? Which court do you approach first?
In this instance, I would actually advise my client not to. And I think this is probably, I would hope that this is something that Advocate Mkhwebane is thinking about, because at the nub of what we're dealing with is, you know, an incapacity and inability to actually deal with simple legal principles. That's really at the nub of the issue here. And I'd think that, you know, anybody who would seek to review something like this, I think it would be a risky approach, given, you know, the legal principles as I know them.
It's so interesting what we're seeing happening in the courts around Jacob Zuma. I mean, this week he lost 2 attempts to appeal a dismissal of an appeal. I think I've got that right, in 2 matters relating to Advocate Billy Downer and Karen Maughan, and then also trying to basically privately sue the president for being an accessory after the fact. I mean, it's so detailed. It's dealing with a private prosecution. We're seeing the courts now talking about an abuse of the court process. It seems that if you want to appeal something, you can find a way.
You can try and conjure up something, as you have just indicated with respect to Jacob Zuma, he lost both of his applications for leave to appeal. And he could also again try and petition the Supreme Court of Appeal and see if he can have a better go there. But, you know, when you read those judgments and you actually understand the scheme of the Criminal Procedure Act and Section 7 and how a private prosecution is intended to be triggered, then it's quite clear that the way he's gone about it is not lawful. And you know, certainly an appeal to the SCA would be seen, in my view, as abusive. And I think the Pietermaritzburg High Court actually had very strong words to say to Mr. Zuma with respect to his conduct overall and in respect of the proceedings.
Yeah, absolutely. Thank you so much for your insights. Much appreciated. That was legal analyst Benedict Phiri. Now, still